Kim, over to you, please. Thank you.
Thanks very much, Stephen. Hello, everyone. My name's Kim Bauer. I'm a lecturer in Norwich Durham, so assistant professor in Norwich Durham, sorry. And I'm chairing today. Just to start off by saying, I'm sure everyone's thinking this, but because it's the last panel today, I'm going to say it. Many congratulations to the organisers. It's been a fantastic conference so far. I'm very, very sorry I can't be there with you. For various reasons, I couldn't travel, but I am experiencing serious FOMO here in Durham, especially because it's snowing. Okay, so this is the last panel of the day, and this panel concerns. I'm just going to get the exact topic right. This is climate change and the rule of law in the courts, and it's the first panel about climate change in the courts. And the question posed to this panel is, whose rule of law? All right, so without more ado, I'm going to go straight into the presentations. We're starting with Professor Anuj Bawania. He's a professor at the Jindal, and I can't read my own handwriting now, the Jindal Global School of Law in Sonipat, and he specializes in, amongst other things, on transformative constitutionalism, and in particular on public interest litigation. So he has a lot of interest to say about this particular topic. So Anuj, I'm going to pass over to you, and yeah, go ahead.
Thank you, Ken. It's great to be part of this conversation. It's been an excellent event so far. So yeah, we're 15 minutes each, I think, and I'm going to try to make the most of the time that we have, right? So it's quite excellent. Well, perhaps a coincidence that the prior panel was on populism and the rule of law, the climate change, because there's been a lot of convergence and an excellent segue into the themes for this panel, as far as I'm concerned, particularly. Now, especially we heard from Professor Jeff King and Chris Hilson about two different aspects of populism. The classic populism instance that Jeff spoke about, and the judicial instance, what Chris spoke about. Now in India, interestingly, we see both versions at play, and we've seen actually both versions at play for almost half a century now. So the classic instance of what Jeff spoke about, of this kind of anti-elitist language of a strong, of a strong executive, charismatic personality, really started in the early 70s in India. This is Gandhi's attack on this elitist Indian judiciary, and that has kind of framed the public discourse in judiciary since then. But from the mid 70s, we saw kind of a blowback in the judiciary in the form of the famed PIL, public interest litigation, which was, in a sense, the emergence of what I call judicial populism, something more similar to what Chris spoke about, as a form of reestablishing its legitimacy in the language of an elitism of its own, in the court being able to speak for the people in an interestingly similar vein. So what I speak about in India that has been in play in the last 5 decades is a kind of situation of competing populisms. With executive and the judiciary both playing the game. Now, the important factor in this is not just the kind of political, context of the 70s and of the kind of give and take of political versus judiciary. It's a judiciary question, very familiar to the UK audience currently, I suppose. But that the Indian Constitution itself makes this possible, because that old counter-majoritarian difficulty with judicial review that you're familiar with, the unelected judges deciding on political questions, it becomes even more complicated in India because of this existence of something called directive principles of state policy. It provides for state aims. That the Constitution itself provides for aims that the state should aspire to. Now, just to connect to the theme of the conference first, because I think you may be lost a little. Why are we speaking about this? Because there's been no area of Indian law which has been more defined by populism than environmental law, arguably, and climate change litigation. Therefore, also because the rise of environmental law from the mid 70s and in India in the early 80s really has been entirely coterminous with the rise of public interest litigation. And public interest litigation is, of course, a direct result of the rise of judicial populism in the late 70s. Now, I see the reflection of these competing populisms in Indian law in three different ways, but actually two ways, let's say, in terms of sense of omission and commission. Now, in terms of omission, because of the fact that the state's aims have been, in a sense, enshrined in the Constitution itself, the idea that the goals of the state trump rights of citizens is kind of given a constitutional legitimacy, and therefore this idea of the argument that the state can constantly make that the goals of development trump environment, that kind of an argument, which is very familiar to perhaps all over the world, but in India particularly has a constitutional legitimacy. And the judiciary, even the supposedly all-powerful in judiciary, has to defer to that, or defers to it in judgments all the time. The second is the sense of commission, what I would call, is the kind of repertoire of judicial populism that we have seen in India is procedural and substantive. So procedural is, of course, classic instances, PIL, relaxation of standing is how it's defined by it, but also all kinds of other departures, including dilution of standards, besides dilution of standing, including dilution of evidentiary standards, as well as, at this point, almost, it's unrecognizable as a form of adjudication, I would almost argue, because it dilutes almost every form of common law adjudication that we know of. And the second aspect of this form of judicial populism in India is in terms of the kind of reckless improvisation in substantive law, and no area again has seen this more familiar in a more familiar manner than environmental law, where Indian judges would just randomly borrow principles from international environmental law, or from or from wherever they deem fit, really, and just apply it, saying that XYZ is customary international law and is also part of Indian law, though India is a dualist system, and therefore so it's interesting to see that in both forms of populism, in terms of the kind of executive-minded populism as well as judicial populism, are in play here, and they get a kind of constitutional legitimacy because of the language of directive principles of the goals of the state, and etc. etc. Now, like I was saying, if you pick up a standard book on environmental law in India, probably the best one being Armin Rosenkrantz and Shyam Devan's environmental law in India, it's literally all about PIL. It's literally about basically one public interest litigation case after the other, right? It's basically a case book on public interest litigation almost, and for no fault of the authors, obviously, but for the nature of the field itself. So so what has happened is that the coterminous rise of the two fields has led to this particular situation that the language of what I call judicial populism and executive populism dominates judicial discourse on the environment in India in general, right? So now, and this is reflected in many of the famed decisions on environment that people would have heard of. I mean, very often one would come across law review articles picking on some random judgment from India, where suddenly a river would be given, a river would be given a legal person status, or something, something quite outlandishly creative, seemingly, right? And it'll be fetishized as this wonderful Indian, innovation on environment, which can be way forward, and there would be, many law review articles written about it. It's precisely the kind of possibilities that substantive judicial populism, in the judicial populism, substantive arena makes possible. completely unthinking creativity of a certain kind, if we may call it that. Now, what has happened throughout this period, and this is a long history to this discourse on environment in India. Mrs. Indira Gandhi in 1972, the original charismatic personality who introduced the language of populism in India in the most, interestingly, a book written in the early 90s on South Asian politics by Aisha Jalal, a well-known historian, talked about the 1970s as the populist era in India. So we really, it's been a while that this stuff has been going on. So in the Stockholm conference in 1972 on environment, Mrs. Gandhi first talked about poverty as the problem of environment in India. Really, that environment is a problem, and since then it's been going on. But I think a thought experiment may be useful here. Perhaps, obviously, the most defining event on environmental catastrophe in India is of course Bhopal, right? What happened in Bhopal in the mid 80s, and the legal tragedy that followed, right? And it would be interesting to think what would happen if Bhopal happens tomorrow again, or some version of Bhopal happens. Well, hopefully not. But I'm just saying that challenge, the legal challenge that Bhopal drew to the Indian legal system, it has entirely failed, right? So environmental law in India is almost a branch of public law at this point, meaning that, and that's a general trend in Indian law, the kind of a cannibalization of private law by public law. So the idea of, so we never think of environmental law as a form of fixing liability on X entity or another. It's just about a means of framing policy, of speaking to the state to frame a certain kind of a way forward. So right from that era, from the mid 80s onwards, where the first so-called environmental PIL started on river pollution, air pollution, etc. And since then, the court has actually done a lot. So of course, the context should never be forgotten that India is seeing an environmental catastrophe, right? That most of the polluted cities in the world are located in North India, which affects about 600 million people, probably the population of Europe, and nothing is done about it. Nobody's really interested in doing anything about it, and politically seen as irrelevant, right? So that is a political context to keep in mind. And of course, India is one of the most vulnerable places as far as climate change is concerned. There's no question of that. But at the same time, we have a situation where where, unlike, say, parts of Northern Europe, environment is a politically irrelevant question. So what happens then? All the hopes are pinned on the judiciary, right? Judiciary becomes the easy access point for kind of a relatively easy access point for addressing all these concerns, and the court seems to have done a lot. Now, what has happened as a result is that the court takes up a matter now, and this is of course done through PIL. Now, PIL, what it means is that, what it leads to is that because of the very form of that form of litigation, is that the affected parties don't have to be heard. The various stakeholders don't necessarily have to be heard. So as a result, we often have a situation where complex questions like air pollution in Delhi, which is the court has been supposedly trying to address for 25 years now, and if anybody has been to Delhi recently, that's not worked, to put it politely. So a tendency to provide kind of a technological fix, a solution to that problem. Now, what we have seen then in more recent times is that well, as PIL has become more and more institutionalized, and the rise of the National Green Tribunal, which has become the new forum where environmental questions are adjudicated in the last 10, 15 years, all the problems with PIL become entrenched in NGT institutionally. So the practice of suo motu cases, the very rise of tribunalization since the last 4 decades in India is a legacy of judicial populism, but it explicitly says that no rules of evidence or procedure, or civil procedure apply to such litigation. So as a result, we've seen that this form of litigation itself is a kind of a rogue litigation, a kind of a litigation which in a sense departs from fundamental principles of rule of law, and it is characterized and has been criticized as a form of bourgeois environmentalism practiced by the court, and of course the court sees itself as the vanguard of such concerns of environmental concerns. So what it leads to is a kind of entrenchment of environmentalism as a bourgeois concern, precisely because it's seen as politically unviable to address these questions. And often as a result, the targets are, in a sense, the people who are the most vulnerable, who do not have access to easy access to the courts. So so this question of how to even begin to address climate change concerns within the legal system in India, in a situation where I'll just try to end here, I think I'm out of time, that perhaps the state is in a sense hastening the various problems. The crisis of climate change has been exacerbated by the state's intervention at some level. What it's doing in Lakshadweep Islands in Arabian Sea, or in Andaman Islands in Bay of Bengal, making things worse. So in that situation where we have the return of a political executive of the charismatic, of the populist kind, in the worst manner possible, unfortunately, climate change has, the issues with regard to climate change has been the biggest casualty. Thank you. I'm sorry for taking more than a lot of time.
No problem at all. Thank you so much for that. I was very struck earlier in your presentation when you said that some of these cases are now unrecognizable as a form of adjudication. But then a few minutes later, I thought I like rogue litigation more. That's very, very thought-provoking, particularly for those of us who wish for more creativity and more initiative from our judges. And I think when you can see a few points further down the line what can happen, actually, we need to ask ourselves questions as to whether this is what we really do want. Okay, so thanks for that. I'm going to turn now to Jonas Ebbesen, who is also online. Jonas is a professor of law at the University of Stockholm, also with numerous areas of interest and specialism, but in particular focuses on access to justice, participation and climate litigation. So passing over to you, Jonas.
Thank you very much, Kim, and thank you to the organizers for inviting me to participate and to speak at this conference. My presentation connects with some of the concerns that were raised by Professor Buvania. And to start with, climate change lawsuits are important to ensure climate transformation through democratic means and the rule of law. In addition to help implementing and enforcing laws on climate change, such lawsuits challenge established legal concepts, bring about new understanding of them, and compel us to think anew. While this is good and creative, we need to examine these lawsuits critically from the perspective of law and politics. And I will center on this very nexus of law and politics and the legitimate concerns that the court in climate change rulings may step into the shoes of the legislator, and thus into the area of politics rather than law. The role of the court in relation to the legislation may be different in one jurisdiction to another, and I think we heard an example of that just before I started. Nevertheless, in all jurisdictions, the relation between courts and the legislature is important for the courts to keep in mind. The rapidly increasing number of lawsuits in all parts of the world are paralleled by the increasing number of climate change manifestations on the streets. These manifestations, just like many climate lawsuits, are reactions to too slow and inadequate political actions to deal with climate change and transform society. Yet lawsuits serves also other ends. they can be used to more effectively enforce existing laws and to hold actors to account. The Dutch Agenda case, finally decided by the Supreme Court in 2019, is one such example. They can also serve to show that existing laws are inadequate. The German case, Neubauer and others versus Germany, decided by the Constitutional Court last year concerning the shortcomings of the Climate Act in Germany, is an example of the latter. In some cases, like the Ashgar Ligari versus the Federation of Pakistan of 2015 and 2018, the rulings are not based on any specific climate legislation, and the court is to apply other existing laws, including of a constitutional nature. In that case, the court held that the government was responsible for being too slow in implementing the climate change framework, thus infringing the fundamental rights of the citizens. This was also the case in the Colombian case, de Justicia y Otros contra la Presidencia de la República y Otros, where the Supreme Court held the central governmental institutions responsible. In other cases, like the French case L'Affaire du siècle and Consent contre France, the court applied also specific climate change legislation and regulations to get to its conclusions. When the applicable law is clear, the issue of law and politics may be less problematic. But what when the law is unclear and not specifically designed to deal with climate change, given that such lawsuits address public interest and climate change policy? In the public debate, some argue that there is a risk that climate change politics is made in the courtroom. I don't think there is much empirical evidence, at least not generally, to show that courts have gone too far in the ruling by stretching or creating laws rather than applying them. Courts are generally speaking aware of the role, which for sure may differ again from some countries to another in what is expected from them. Still, it is a relevant concern. You cannot justify any court ruling just by referring to the urgency of climate change. There must be a solid reasoning linking the outcome to existing law somehow. And I will illustrate my point with 3 examples of cases, potentially seen as getting close to politics. My first case is about human rights and climate change. Human rights law has come to play a more important role for climate change transformation through the lawsuits than was the case before. Human rights has been part of the climate change discussion since the 1992 Rio conference, but they have played a rather marginal role in legal context until this link was increasingly confirmed by the courts. This connection is found in cases in Pakistan and Colombia, as well as in the Dutch Agenda case and the pending Belgian case. This is a welcome transformation, and I think the Dutch court in the Agenda case reasoned very convincingly on why and how the European Convention on Human Rights was applicable to climate change. I agree that the convention is applicable and imposes a burden on governments to deal with climate change. Still, one can say that it is quite a step to derive climate change duties from Article 2 on the right to life, Article 8 on the right to respect for private and family life, given that the convention neither mentions environment or climate. And for sure, it doesn't say anything about a reduction by 25 or 40%. In fact, it was not until the 1990s that the European Court of Human Rights started to develop what is now a solid jurisprudence on human rights and environment protection. And it is on this jurisprudence that the Dutch court was based its decision. The court in the Agenda case did very well in showing that its conclusion was legal rather than political. It also explicitly reflected on these matters and explained why existing provisions supported its conclusion. This, I think, is important since the ruling has huge political consequences. My second case is about standing in court and the right to participate in decision-making. More precisely, it's about who is concerned and who has an interest in the case. In quite a number of jurisdictions, unless providing for actio popularis, some requirements apply for standing in court. You usually need to show that you are somehow concerned or affected by the matter before you, or that you have an interest at stake. In some countries, you also need to show that you are concerned or affected even to be able to participate in the decision-making. While it may be possible to distinguish who is concerned by noise or smell from factories, How is this category to be defined in climate change cases? Who is concerned by an activity which adds to climate change by its emission of greenhouse gases? Or more accurately, who is not concerned? Actually, you are not less concerned by such emissions, and you may not have less interest in such a case if you live in the other part of the world than if you live just next to the activity in question. In my years in the Aarhus Convention Compliance Committee, where I was the chair for 10 years, we had an interesting case concerning public participation and about who is concerned and has an interest, which illustrates my point. This was not about climate change, but it was about transboundary contexts. In this case, a German citizen, it was called C91, a German citizen argued that the United Kingdom failed to comply with the convention because she had not been duly informed about the decision-making procedure concerning the nuclear power plant at Hinkley Point. She would have been allowed under the laws of the UK to submit her comments, but since she didn't know about it, she couldn't provide her views. Was she concerned, or did she have a sufficient interest living more than 1,000 kilometers away? In that case, the Compliance Committee found that the UK failed to comply. It held that in such cases, members of the public also in Germany should be seen as part of the public concerned with regard to nuclear power plants. Despite this distance, this was later endorsed by the meeting of the parties, but what if the communicant had been brought by someone further away in Bulgaria or in Central Asia, who are also parties to the convention? Where would the committee draw the line? And what in a case concerning climate change? Is there any geographical limits whatsoever? My point is that the court will have to develop jurisprudence on standing and participatory rights in climate change cases, and in doing so, somehow relate to existing concepts and principles. Would the court then provide for a kind of actio popularis, even if the applicable legislation is intended to limit standing only, in quotation marks, to those who are concerned or affected or have an interest? My last point is about causality and the allocation of responsibility. Courts are well equipped to deal with such questions. Still, climate change lawsuits challenge existing concepts. I will give you two examples from cases that have not yet been finally concluded, to my knowledge. The first case is Luciano Lua versus RWE, in which a Peruvian farmer sued the German energy company, claiming compensation for measures to protect his property against glacial floods from the Andean Lake in his vicinity. In this case, the plaintiff argues that the defendant is responsible for the cost for adaptation based on the contribution of the defendant to global greenhouse gas emissions, which is 0.47%. This is presented quite logically. In most jurisdictions, you would indeed be able to claim compensation based on the rate to which the defendant contributed to the harm. But even so, this is still quite a complex case with numerous contributors to the harm. The case serves not only to help the plaintiff to be duly compensated, it also highlights that someone is responsible, although at the other side of the Atlantic, to the harm. If successful, it will show a way to deal with complex cases of allocation of liability and causality. It would break new ground in tort law, but maybe it would not be so problematic in this case from the perspective of law and politics, despite the huge transboundary repercussions. Then, what about the rather controversial and also very creative pending Dutch case, Milieudefensief versus Royal Dutch Shell? In this case, as you know, Dutch NGOs sued Royal Dutch Shell in the same court as the first instance of the Urgenda case, that is in the District Court of The Hague. Here too, the case is about the responsibility of a large defendant, although now a corporation, to significantly reduce the emissions of greenhouse gases. In this case, the District Court ordered the defendant, the holding company of the Royal Shell corporate group, to reduce by 45% by 2030 relative to the 2019 levels, the emission of the entire corporate group, including about 1,100 subsidiaries in about 160 states. The legal ground for the ruling, when ordering Royal Dutch Shell to reduce its total emissions, is in the due diligence provisions under Dutch tort law as set out in the Civil Code in light of Article 2 and 8 of the European Convention on Human Rights and other international documents, including the UN Guidance on Business and Human Rights. This case involves quite a few controversial issues. While formally building on a provision in the Dutch Civil Code, the ruling covers all activities of corporate groups for which the Royal Dutch Shell is the top holding company in, as I said, 160 jurisdictions. The reductions to be achieved includes the emissions by consumers of the products, that is, of the fossil fuels of the company. An important legal question, and some would say political, is whether a Dutch court can have jurisdiction to rule on activities in 160 states, including essentially every gas station in the world in this corporate group. Some states may argue that it would be for them rather than for the court in the Netherlands to decide on how to regulate emissions by corporations and activities under their jurisdiction. It is not my point to criticize the ruling, just like cases concerning the responsibility of states. This case shows that someone is responsible for emissions, although it's fair to argue that we are all responsible for our emissions, even if we buy our fuels at this oil company. My point is that the ruling have far-reaching legal and political consequences, and the court needs to argue from a rather strict legal position. If not, then the court will be accused of stepping into the political arena, and the ruling may be perceived as illegitimate. So, to conclude, where does this lead us? I have three main points. First, in a time when some actors complain that democratic societies are incapable of dealing with climate change because they are too slow, and some are desperately looking for political leaders who forcefully impose climate change restrictions without further ado about democratic decision-making. The lawsuits show that climate change transformation of society is possible without compromising on democracy and the rule of law. Second, the court must respect their role in climate change governance, which is to apply and enforce existing law, and also to make sure that laws intended to ensure basic human rights and other rights are upheld and complied with, both by states and by corporations. This will remain a challenge, but so far my impression is that courts have shown readiness to navigate correctly in this landscape of law and politics. And finally, my third point, the rule of law is not only about applying the law correctly and of upholding legal certainty and foreseeability, and by only I put that in quotation marks, it's of course very essential, but it is also about ensuring that everyone, also states and governments, must act in accordance with the law and can be held accountable when they don't. Climate change lawsuits are important means to that end. Thank you for listening.
Thanks very much, Jonas. That was super, super interesting, and also particularly interesting to me. So I was very, very happy to hear that. One of the things that some of us have said before about climate cases is, yes, they're important, and I agree with you. They certainly can move things forward, but also frequently we need to re-highlight, whoops, my alarm. We need to highlight the importance of academics and the importance of critical analysis of these cases to assess exactly what they are doing and whether they are effective, and whether more needs to be done or less needs to be done. And of course, questions about legitimacy come in there as well. So without further ado, we come to the last panelist, who is live in the room from South Africa, Professor Ademola Jegede. Professor Jegede is a professor at the University of Venda in South Africa and specialises in climate change and environmental law and human rights. He's speaking today about Indigenous people's rights, but also has an interest in and specialisation in climate litigation. So Ademola, without further ado, I'll pass over to you.
Thank you, Kim. I was hoping to see you here, but as fate will have it, you were in, you went to South Africa at the time I came here. Hope you're not running away from me. Yeah, thank you once again. You know, University of Venda is, for those of us who don't know much about South Africa, University of Venda is situated in the northern part of South Africa, and it's one of the most historically disadvantaged university there. During apartheid, it was literally abandoned. So it's a university now trying to pull its weight, and I know we are doing the bit we can to take it to that level where it can favorably compete with others. So now, having said that, I just want to share some views with us in relation to the protection of indigenous peoples, particularly issues that are of vital importance to them when we talk about climate change. So, and in my sort of work, I'm a bit regionalist in the sense that for some of the issues that pertain to indigenous people, the challenge has always been at the domestic level, lack of recognition, lack of attention. So what you observe is that resort is often held by civil society to the regional institutions to ensure that protection is attained for these people, and so that when such is obtained, then civil society activism can happen at the domestic level to ensure that decisions that they obtain at the regional level translate to meaningful impact on this vulnerable population. So essentially, my presentation would circle around that, and so I just want you to understand that within that context. So when I talk about struggling to be heeded, climate, rule of law, and the protection of indigenous people's land rights under the AHRS, I'm referring to the African Human Rights System. And what we'll see is that there are no knowns, in relation to these issues. We may contend certain things, but then for the indigenous people and local populations, there are things that we know about their situation, which we can refer to as the non-knowns. And one of those things is that in the UNEP decision 2079 articulates what environmental rule of law is in terms of ensuring that there is effectiveness in the implementation of, the operationalization of institutions around the protection of environment. And of course, the decision also sort of encourages all stakeholders in that field, in that space, to work towards the effectiveness of the institutions in addressing challenges pertaining to the environment. And of course, we also know that for the indigenous people, there are devastating consequences of ruling climate system on them, and these are populations that are highly responsible when we talk in terms of causation of climate change. And of course, some might argue that when we talk about causation of climate change itself, the whole entire continent of Africa contribute least when you look at it proportionally. And so the argument will be that why do you focus on these populations when the entire continent is disadvantaged? But then what we say essentially is that for these local communities and indigenous populations, their own vulnerability, I think, in the context of African disadvantage is double in the sense that they come from a continent that is disadvantaged, and double in the sense that they also have an identity that is least recognized. And of course, that will explain why at times we separate these vulnerabilities from vulnerabilities. And I think it's so important that we do that, otherwise the whole, it will be very difficult for us to kind of, emphasize their challenges for attention. And at the heart of these devastating consequences is their land, which is so crucial. Land is useful not just for the indigenous people, but of course it's also very important in climate change, international agenda. And land is crucial forestation, afforestation, or reforestation. Land is crucial to the implementation of sustainable development projects. Land is also crucial to we're all aware of RED Plus programs happening in no less than I think 37 African states. So all these projects, in a way, impact on these populations that who have traditionally depend on land resources for their survival. And of course, that's not the only thing. Land is also of spiritual essence to them. It is where they have their being, where they are culturally connected. So, but then the problem that we have at the domestic level is that the state does not often pay meaningful attention to these issues that are of relevance to indigenous people. And I can cite examples, all over Africa. Time will fail me. I can talk about indigenous people in Kenya. Lately there was a program, I think, which brought about the eviction of Sengwe people in Kenya. And of course, the program is all about preservation of the forest in the interest of minimizing deforestation. And of course, in the process of doing that, government sort of chased them away. And so you see that this is a live issue. And I can also talk about South Africa in relation to fracking that takes place in most of the Western and Eastern Cape. So in Nigeria, I can talk about the environmental degradation activities that happen in Ogoniland and other. In DRC, I can talk about the Kiwa community where, as a sort of extractive activity of multinational companies, there is what I can call interconnectivity of, brute and murder with harvesting of environmental resources. So all these are in a way linked to climate change issues, because at the end of the day, they affect these populations disproportionately and of course cruelly too. So what another known that is lack of recognition of these people at the domestic level. Like I said the other time, when you try to isolate populations from populations in Africa, the response is always that, but we are all indigenous in Africa. We are all victimized. We are all underdeveloped. Why are you separating one from one? So, and there's also the issue of inadequate public participation. Government often implements some of these projects by just ticking the box. And they do so because, for them at times it's also a waste of time in assessing some of the funding that is available at the international and perhaps also regional level. And of course, there's also limited access to justice at the domestic level, because, which is quite, a consequence of, the lack of recognition. Because now, when you don't recognize a group as existing, it becomes quite easier for them to be denied, access to justice on that basis. Individually, they may not have a problem, but when it comes to collective ownership or communal ownership or communal litigation about such resources, it becomes problematic, because government will definitely see that as a threat to the interest to kind of develop, rapidly, which at times are often genuine intention. But then the way they go about doing is reckless, and not just on the rights of the indigenous people, but then of course also in the broader discourse on climate change. So, and there's also often lack of political will on the part of government to do much in terms of the protection of these people, perhaps because of the bigger interest of multinational companies, which are often kind of, they often have overbearing influence on government in terms of what they can do and what they cannot do. As we know, these are powerful entities that, government at times has entered into all sort of memorandum of understanding with. So even if you get judgment at that level, it becomes very difficult and challenging implementing the judgment against them. That is why at times you see cases, being flown extraterritorially, Shell being sued in England, being sued in Netherlands, and all that. Not because there is no judiciary in those legal system, but because suing multinational corporation in relation to such activities. It's like suing the state itself, because the state, there is a convergence of of belief in terms of how resources should be harvested. So indigenous people suffer more because their land is often at the center of all this tension here and there, and so that becomes quite problematic, to kind of student. Then access to information is also key. It's one of the known knowns that indigenous people suffer from. Because I was having a discussion with some of the colleagues when we were having lunch. They were talking about different issues in relation to access to information. Indigenous people and local population are not aware of some of the development that happen at the international level, access to funding, access to these. Even the science of climate change has been projected at that level is at times very too political for them. So which makes the issue of access to information very challenging, because when you don't have access, when you don't know that there are possibilities at the international level for you, there are possibilities in terms of funding, it becomes very easier for the elites, to corner whatever opportunities that are at that level and use it for whatever purposes they want. On papers we hear, okay, this government, South African government, is giving so much money to fight, to address adaptation challenges, mitigation challenges, or Nigerian government has been giving this. And the question is, does it kind of, how does it impact, activities at the domestic level, which is very crucial to the welfare of these people. So access to information is also one of the things that has been struggled with. And one of the things that one of the known knowns that I'm also kind of arguing is that there is an African human rights system which is a bit young, but then is developing and very quite proactive. The African human rights system, I'm referring to the normative framework that exists within that system, and of course all the treaty monitoring bodies that are there, like the African Commission, African Court of Human and People's Rights, and of course we also have a treaty monitoring body for the Children Charter, which in form of the African Committee of Experts on the Welfare and Right of the Child. So these are that normative framework, along with the treaty monitoring bodies, constitute what I'm referring to African human rights system. So we see that there is a development at that level which sort of favor, if I may use the word, indigenous people's concern, because at that level they have been recognized in a lot of decisions. At that level, some of their rights have been canvassed. We've seen cases such as the Andrews case, the Kiwa case, like I said, in the DRC, where not only the right of the indigenous people are recognized, but then the general plight that they suffer in the context of developmental projects are recognized there. Then we also seen other cases where, at that level, where issues such as environmental degradation, talking about the Ogoni land case, and their general communal land rights are protected, and I'm talking about the Andrews case. So these are possibilities. All these possibilities are not in the context of climate change, so to speak, but these are possibilities that exist within the system. So what I call the known unknown now, that is what we know that we do not know, is that whether the African human rights system can address the failure at the domestic level in addressing issues that matter to indigenous communities, particularly in the context of climate change adverse consequences. I say it is unknown because as I speak, unlike other system, inter-American system, and as Chris presented the other time, as you can see, the European Court of Justice, we don't have a pioneering case yet at that level. So how it can be different is what I try to sort of look at. And my argument is that African human rights system can advance some of the rule of law values to sort of attain climate justice for indigenous people. The actors at that level can initiate pioneering litigation, and in my paper I argue that can be done. And of course, I also look at the mandates of these bodies to show how the promotional, the protective, and interpretive mandates of these bodies can be used to shape events at the domestic level. And of course, I also talk about the implementation monitoring, which is beginning to emerge in the activities of the treaty monitoring bodies at that level, and how important and significant it is to shape, to affect positively the issues that indigenous people are passionate about at the domestic level. So those are my presentations. Kim is already on my neck. So we should, in my custom, we say a shigam, meaning that thank you very much for listening.
Thanks very much for that. Sorry, I have been a slightly mean chair, but never mind. Thanks for that very interesting presentation. And yes, you've highlighted something that I always try to explain to people as also someone coming from Africa, that the idea that there's a sort of homogenous population is completely wrong. There are elites and there are, as you highlight, very, very vulnerable populations, even in what is globally a disadvantaged continent. So there's lots to unpick if anyone wants to examine Africa more closely. Great, thanks Stephen. Thanks very much to the three panelists for your fantastic contributions, and thank you for the questions. Again, I'm not going to stand in the way of wine, so that's the end of the session for today from the online chair.
Thank you, Kim. So